Ryan, thanks for your time. So I guess the filings were in late last night to Judge Wilken from the NCAA and the Power Conferences, and it seems like they've moved a little bit, but it still comes down to not quite, I don't think, what Judge Wilken was wanting it to do. What's your reaction?
I agree, and thanks again for having me. I agree with you. I don't think this goes as far as Judge Wilken wanted it to go. I think her order was fairly clear that roster limit issues needed to be addressed, and the immediate implementation of those roster limit issues needed to be addressed. I think she was clear in that the schools created their own problem by implementing prematurely the roster limit issue after preliminary approval. I'm not necessarily sure this goes all the way, but look, this is in the hands of the judge now. She can review the revisions to the now fourth amended settlement agreement. She'll have the benefit of the objectors when they file their responses, and then counsel will have an opportunity to file a reply. And I suspect she'll issue a decision before the end of May to allow the schools enough time and the athletes to effectively figure out what's going on here before July 1st.
So I saw the one of the objectors, Steve, I think Molo, on the settlement. They don't like it.
They don't.
And so if they don't like it, that's what the judge is going to lean on, right? Because she's there for the plaintiffs, or the ones who are the objectors, excuse me. Is the NCAA and the Power Conferences, are they playing with fire?
Well, they're certainly taking litigation positions, that's for sure. As you can see with their supplemental submission after supplemental submission, they don't, for whatever reason, fully want to give the judge what she's asking. I'm not in the room. I don't know the legal strategies behind that, but it would seem fairly simple to me to be able to tell Judge Wilken, look, we heard you. We understand what you're saying, specifically with respect to the negative harm, although that being redundant, I guess I should say just harm visited upon current college athletes and current high school seniors who have committed to universities to play and have had roster spots. And we will not implement roster limits until all of those kids are out of school. That would alleviate any harm to any athlete presently in a university or a high school senior who has presently committed to a university. Almost like the death penalty, right? I think we talked about that last week. Implement this 4 to 5 years down the road. That way, it allows all of the current college athletes and high school seniors who have committed to play an opportunity to get in, not be fearful of this ever impacting them, and get out of school. And then you can implement it so that the high school freshman today will have to deal with roster limits down the road. The high school junior today or sophomore today will have to deal with that down the road. But your current college athletes and your current high school seniors who have already committed, and they won't have to deal with this issue. They won't have to look over their shoulders for their 4 or 5 years in school. Right. That would be the simple approach.
I don't know if you saw this, but I happened to see this. It's from an attorney, Mitch Gilfillan, I think his name is. He goes, House dilemma. If schools have option to re-roster spots previously cut, they may not have the room or money available. From a Big Ten assistant coach, quote, no choice or no chance are we giving those spots back. That ship sailed with tightened budgets and revenue sharing.
I saw that quote too. I'm not surprised. As I mentioned yesterday on X, I'd be surprised if any university unwinds their decision to cut roster spots. Although I will give credit to Notre Dame, who has come out today,
I saw that, yeah,
to take the very opposite position and say, look, we understand the environment here. We understand what's going on. And, we are not going to, we're going to honor those student athletes who have roster spots, and for anybody who has transferred, you can come back. A great approach by Notre Dame. But I'm not surprised that other schools may take a different approach. Look, they've complained about the issue all along, about having to now unwind that which they have already done. As Judge Wilken noted, they have created their own problems. Yep. So this whole ship has sailed, it's too expensive, we don't have the money. Well, you created that issue. And if a federal judge tells you to unwind that which you have already done, you don't have a choice. You either do it or you're in contempt of a court order. So, the schools can proceed at their peril. They can do what they want. But if I'm advising them, I'm saying to obviously to any school, you have to honor a court order. And if the court order says you have to, allow student athletes to come back, and as a result of that, other student athletes on those rosters are not harmed, then you have to do it. I mean, imagine a scenario where you have, a roster limitation of 15, student athletes then leave, and now they're allowed to come back. Well, what happens to the other student athletes who are on that roster? Are now they subject to a roster limit? As I mentioned before, I think the easiest way to resolve this from a practical standpoint is implement this stuff down the road. Let all of the current college athletes participate in their sport at the universities of their choosing without fear of looking over their shoulders, wondering if they're going to be here today and gone tomorrow, and let them compete and graduate and cycle in and out of college athletics unharmed, and then implement your roster limits down the road.
Which was more of a mistake? They continue to go back to Judge Wilken by not quite doing exactly what she's asked them to do, or that they jumped the gun because they thought this thing was going to be smooth sailing and started making roster cuts?
Look, I think certainly in acting post preliminary approval, I'm not sure that was. Look, I don't know if it was a strategic decision to do that, or what. I mean, we could have an argument and debate on that issue, right? Did the schools intentionally act prematurely to create this situation to say, Judge, hey, we can't go backwards now. This is what your, this is what preliminary approval caused, and look, we can't go backwards. I think, look, I've handled class actions on both sides of the V. Implementing, major substantive provisions of a mere preliminarily approved settlement agreement that does not have the benefit of objections, right? That to me was a little odd. I do understand the school's position that, hey, look, we're on a timeline here. We need to know what we're doing. And it can't be, we can't make all of these decisions and budget issues and resolve all that stuff within a week. We need to have, a good amount of time to do that. So, I guess I understand from an outsider looking in perspective, maybe why the schools jumped the gun here. But again, they created the situation in which they now find themselves. So, I don't think, telling hundreds upon hundreds, if not thousands of kids that they no longer have a roster spot was probably the best way to go. In addition to that, almost disputing what the federal judge is asking for is probably not the best idea either, right? I mean, she holds the hammer here. She could say, at the end of the day, after getting the objections in on the 13th, I mean, look, this all comes down to fundamental fairness, right? Mm-hmm. So she could say, I appreciate all of the work that everyone has done here to try and give me a suitable and approvable in final form settlement agreement. But I just don't see it. Motion denied. We already have some dates in the case management order for motion practice on experts and things like that. But now I'm going to set a trial date. And as I had mentioned before, once she sets a trial date, you just wait to see how fast, people come to the table and say, all right, Judge, we'll give you what you want. Because I don't think in any capacity the defendants want to go forward with a trial.
Ryan Mulvaney with us, and man, it's great to get your knowledge. You saw perhaps the story, Nick Saban, Texas Tech Board of Regent, and a billionaire donor, Cody Campbell, have been, I guess, co-chairs of a presidential commission. Can that thing get anything done? Is that just another committee, and yet nothing gets done? What can get done with that, in your opinion?
As they say, if you want to get nothing done, you put a bunch of politicians and lawyers in the room. So this is the concern I have. I really hope that they expand. I know, Coach Saban is this is just recent, right? It was, I believe, yesterday, and AD Campbell, I believe today or late yesterday. So this is new. I'm hoping that in the composition of this commission, they include voices that we heard from objectors in this case, right? Olivia Dunn's of the world, the high school athlete, and forgive me, I forget her name, but she was so passionate. She was a high school senior who had lost her roster spot. Folks like that, lawyers who represent athletes, not just surrounding themselves with, in a vacuum of sorts where they only hear their own voices. If President Trump really wants to solve or attempt to solve some issues here with this commission, then people who have differing opinions and different voices need to be on the commission.
How long will this take for Judge Wilken to have a final say? And when she has a final say, is that signed, sealed, delivered, and move on one way or the other?
Well, I don't think she's going to let this linger on. I think she set a pretty quick turnaround for objectors, and then the reply brief, all of 3 days, almost like an order to show cause, some sort of emergent application. So she wants briefing in very short order. I suspect she'll have an opinion out before the end of May, and then we'll see where we go from there. Will somebody appeal it? Who knows? Obviously, there are a number of objectors who may or may not be satisfied with the final approval, if final approval is granted. And then, look, we're still going to have more litigation, even if it's not appealed. Let's say Judge Wilken grants final approval. For whatever reason, everyone is satisfied and happy, and we all go along, move forward together. There's going to be litigation about the salary cap of $20.5 million. I guarantee that. There's going to be litigation over the Deloitte fair market value determinations. So I don't see litigation ending. I see other avenues of litigation to commence. And we'll see what happens if the parties appeal, and by parties I mean the objectors to the settlement, if Judge Wilken grants final approval.
Lawyer, litigation, sports, NIL, entertainment, NBA agent, among many things that Ryan P. Mulvaney does for a living. The knowledge, the insight, the law. Thank you for your time. It's Ryan Mulvaney on 365 Sports.